Hamrick, you want to come on up here? We're going to do Georgia Statewide Business Court next.
Good afternoon, Mr. Chairman and members. I'm Bill Hamrick, the Statewide Business Court Judge. Andrew Zoll, who does our budget along with a few other agencies, is with me. And Emily Youngo, our new clerk, who I want to make sure I bring with me so that y'all know who she is and how to contact her if we can answer any questions at any time. We are at, well, first of all, I want to thank you as well as the other judges for everything you do for us. Echo their thanks for the salary adjustments, and that is part of our request as it was in theirs at 6.8.1. We have the same request to fund it second half of this year, and then to the number for next year, FY27, that would fit within the tiered system, and so our number would depend on what you do with regard to the other salaries, so we're asking for that. We're also asking for, in this budget, as we did in the supplemental, a little bit of funds to make sure our clerk salary equals the Court of Appeals clerk as is required by 15.5A11 statute. And then the last request at 6.8.3 is just for the second half of the year funding for the retention raises from the last budget.
Great, thank you for that. Only 3 items here. So any questions from the committee? See any questions at this time? So really appreciate you presenting and appreciate what you do for Georgia.
Thank you. If you have any questions later,
We sure will.
Answer. Thank you.
All right. How about Georgia Tax Court? Welcome. Thanks for being here.
Thank you, Chairman Gullett, members of the committee. Thank you for having me here today to present for the new Georgia Tax Court. I'll start with some sort of overall explanation. When the original number was submitted, my assumption was that the tax tribunal budget would be carried over. I'm going to try to start out building on the tax tribunal's location, operations, what have you, makes the most sense. However, the tribunal is in the executive branch, this is in the judicial branch, and so the funds could not be brought over. So in the governor's budget report, the tribunal funds were eliminated, but due to those separation of power issues, they weren't transferred to the court. Considering that, Andrew and I have worked on a more zero-based budget and have a document prepared to provide to you and members of the committee and your staff. But I would like to make a couple of observations. But first, I'd like to thank a few people. Starting up a new court takes a lot of collaboration, and the support and assistance of Chief Justice Nels Peterson and the AOC, Cynthia Clanton and Andrew Zoll, and the Chief Judge Bogg, all been very gracious and accommodating. And when this number was first submitted, I wasn't sure where I was going to be. I knew that the OSA judges didn't believe that we should be on the same case management system, being in different branches of government. So there were some big issues to settle. Now the OSA judges have made it clear that The tax court can continue to rent space where Judge O'Neill is, so that settles the location question. Case management was another big question, and I met with Ben Luke a couple weeks ago of the AOC, and he saw no issue with getting the tax court onto the new case management system by our July 1st go-live date. So things are very much shaping up for the court. And in fact, we've got a meeting on March 10th between the OSA IT folks and the AOC IT folks to talk about transitioning in the case management system. The numbers before you in Section 6 for the tax court 6.10, the first item, like the other courts, to increase funds for the judge's salary to the maximum authorized by House Bill 86, and then funds for a staff attorney position. Those amounts, had they been added to the tax tribunal budget of $582,000, would have been a budget of $915,000 approximately. But the document that I'll provide to you, the request will be $817,000 because we've got some questions answered favorably. As I said, I'll provide this document to you, totaling a request of $817,000, and we'd be happy to answer any questions you may have, sir, and members of the committee.
Great, and I appreciate your help during the amended budget. I know there were some opportunities for some cost savings on our part, and we appreciate you being good stewards also of taxpayer dollars. It's very helpful to us. Are there any questions? None? There's no questions. So thank you for your great presentation, and we look forward to, if you just want to hand that to either email it to us or get it to us now, whatever's best for you.
Yes, sir.
We'll get it to the committee. Thank you so much.
Thank you, Mr. Chairman, members of the committee.
Bet. All right, JQC. And for members on the committee, we also handed out some information she gave to us prior to the meeting, so it's in should be on your packet. You're ready.
Good afternoon, Chairman Gullett and members of the subcommittee. I appreciate the opportunity to be here to present on behalf of the JQC. My name is Courtney Veal. I'm in my third year as the Commission's director. And I prepared some information for you all just based on some of the questions that I've gotten in the past and based on the fact that I am likewise an attorney that is not good at math. But, you know, I think there is a big portion of what the Commission does that goes unseen. And that is a product of our statute. Of course, we're required to keep some of our matters confidential and our rules. And so my hope was that in preparing this information for you all, it would assist you all in seeing some of the work that we're doing that is, again, perhaps unseen generally by the public. So I'm on the track sheet section 6.5. We have 4 items on there today, and so I'll start with 6.5.1. That is an increase in funds for personnel for a second full-time investigator position. So as you'll see with the data that I have prepared, between 2024 and 2025, we saw a 25% increase in the number of complaints that came into the Commission. So in 2025, we ended at 2,083 complaints. When I started at the Commission back in 2020, we saw around 500 complaints that year, and so you can just see, based on the information that I've given, that we have continued to grow every year. I've said this before, but that's not the result of judges just all of the sudden behaving badly. I think it's a product of a number of things, but the increase between last year and this year I think there are a few factors at play. One of those being when we are litigating, all of our hearings are public. We live stream our hearings so that anybody can log in and watch them, but when the public sees that an agency is out there and they're litigating and they're trying their cases and doing the work that the agency should be doing, we have seen a good number of complaints come in thereafter, right? I think a lot of people don't even know that we exist in the first place, and so when they see that out there and they see the media coverage, they see that we exist. And I also think with the advent of the live streaming of court proceedings, which is becoming more and more popular across the state, we've had several high-profile cases tried in this state between last year. We have some going on this year. The result of that happening is that the chatter in the stream chat a lot of times includes us and people sharing our website. Whether I like it or not, that's our reality, and so we're seeing a lot more complaints come in as a result of the live streaming. So to this point, the commission has operated with one investigator, and that is since the commission's inception. We have continued to do that and done our best to make it work, but our reality is that with the number of complaints we're seeing coming in, as that increases, so does the number of investigations that we're conducting. And you can see the number of investigations has gone up 27% between last year and this year. One of the problems that we've run into with just having one investigator is if he is somewhere doing court observation or interviewing witnesses, or he's off trying to get a witness served with a subpoena and something else comes up, we do not have anybody else available to perform those tasks. I do my best as an attorney, and I know the attorneys will understand this, but I do my best to try not to interview people without my investigator present being a witness, but unfortunately, both myself and the other attorneys on the commission sometimes wind up in that position because we just have the one investigator who is often out in the field and away and handling the business of our investigations. And so my ask in 6.5.1 for that additional investigator is the result of our increased volume, both with the number of complaints and then our ongoing litigation efforts, which as you will see, last year we had one hearing in 2024. Last year we had 2 hearings. Those are our trials. And both of those, by the way, are currently pending at the Supreme Court. I made the recommendation for removal in both of those circumstances. Our hearing panel also, after making their findings, recommended removal of those judges from office to the Supreme Court. Item 6.5.2 is a request to increase funds for security. And just briefly, in kind of following what Justice Peterson spoke about earlier, as I'm sure you can imagine, a lot of the people who are mad at our judges are also mad at me. And so to the extent our judges are dealing with threats and harassment, I have been the subject of threats and harassment personally, as well as members of my staff. And so, again, people get frustrated, they're mad at a judge about the case or the outcome. They then find us, and if things don't go the way they hope with us, we have seen, again, the threats and harassment. And so I am not asking for a detail or somebody to go around with me, but what I am asking for is preventative. And I want to be clear in that GSP, I know that they are, and they have been available to us if there is anything acute or emergent. And so I am talking more about preventative security, and what that looks like for us is myself and my investigative panel meet once monthly, and a portion of all of our meetings is open to the public. And so what we will see is there has been an increase in interest by the public attending the open portion of our meeting. That's fine, but there have been a few situations where somebody has shown up and they are upset and we don't have security there. We meet in different locations. We move around the state because my commissioners are located all over the state, and so my commissioners have become of the opinion, and I am of the opinion, that we need to have security present at our meetings. And so I think the question is, what does that look like? And to date, when we meet in Atlanta, what has happened is that we have requested GSP to have troopers there. Sometimes that has happened, sometimes they're not available. And again, Hearing what Justice Peterson said earlier, they are spread incredibly thin, and so what will happen is generally they will send Capitol Police. But that's only an option if we're here in Atlanta. It's not an option if we're, off-site in Macon or Savannah where we have members. And so we have spoken, one of my commissioners has had conversations with GSP, and what we envision is working with them on essentially a contract basis and giving some of these hardworking troopers the opportunity to be paid when they are off duty, to come to our meetings and be present at our meetings. Another issue that we have, and again, Justice Peterson touched on this, we are a statewide agency. When I am litigating our cases, we do not have security there. There's not, wherever we are, whatever the location is, sometimes we're in a courthouse, other times we're not. We aren't pulling the local law enforcement or the county's security. We're a state agency that's in there, litigating. And so, again, members of the public come to those hearings, and I think the responsible thing for us to be doing is to have somebody, even if it is just one trooper who is off duty, who says, I would like to, make some additional money this week and be present for this proceeding. That is what we would like to do. And so I'm glad to take questions or answer any questions offline that may direct relately to the security issues that I've talked through. That then brings us to item 6.5.3, the increased funds to support growing operational costs, including litigation. And the information that I provided to you all, I wanted you all to have an idea of just the increase in court reporting expenses that we've seen. I'm sure you all have heard from various individuals. There's been a court reporting shortage across the state, and that's not anything that is new. But the result, at least what we've seen, is we have to have a court reporter. All of my cases are going to go and be reviewed by the Supreme Court, and so the cost is the cost. But you will see that in FY 2026, we have expended $51,955 just on court reporting services. And you'll see that in 2025, we were at around $4,000. So that has increased exponentially. Obviously, that figure captures the two trials that we had last year, and it will also capture when we do certain things at the investigative panel level that are confidential, whether it's a judge coming in or witnesses coming in, that we have a court reporter present for that as well. So just in that space, I wanted to demonstrate the way in which our operational costs have expanded in conjunction with our litigation and our increased complaint numbers. And then my last request is at 6.5.4. That is an increase in funds for personnel for a fourth full-time attorney position. So again, I gave some information about what each of my attorneys on my staff currently do. There is me. And so I cover all of the administrative pieces of what is handled for the investigative panel. I am also the lead prosecutor on all of our cases, and that's based upon the way our rules are written. And so I try our cases, and I do this piece and all the many things in between. I also supervise our staff. I have a deputy director who is an attorney. She and I essentially split the caseload of our cases that are investigated, and that we are proceeding on pursuing discipline. So we do split the caseload up once it's at that point. And then I always try to have a second attorney with me when I'm prosecuting our cases, just to have a second body there. They take some witnesses, help with the presentation of the case. And so she does portions of investigations and prosecutions. She also handles the bulk of our ethics guidance and inquiries. So just like the State Bar of Georgia, for my lawyers, they are tasked with, they have an investigative and prosecutorial piece to their body. They are also there to provide guidance to members of the bar. There's a lawyer's assistance hotline that exists that lawyers can call up, and if they have an ethics question, they get guidance from the State Bar. We serve that same function just for judges in the Code of Judicial Conduct. And so my deputy director handles most of those. She and I do split the ethics trainings from across the state, and as you all can see, I've charted that out as well. Our requests to provide ethics presentations and trainings to the judiciary have also increased, and so at nearly every judicial conference in the state for each class of court, either myself or my deputy director is there to do the ethics component of the training for our judges. And I think it's a good thing that it's increased, but as that increases, so does the time taken from our investigations and prosecutions. And so I've got a staff attorney. She focuses primarily on the intake and the initial screening and review of all the complaints that come in. For a fourth attorney, what I envision is having that person act as kind of a general counsel, somebody that could help me with some of the administrative pieces of what we do. So this, as much as I love appearing in front of you all, helping me out with budget, and Mr. Zoll, by the way, has been wonderful, although sometimes I feel like I jeopardize too much of his time. But having somebody to help me with the administrative pieces of what we do, having somebody kind of act as a counsel for the investigative panel, my investigative panel. Sometimes there are legal questions and issues that come up. I can't tell you the number of times I have read and studied Open Meetings Act, Open Records Act, and just those kinds of things, because I am also the prosecutor. Wearing all of those additional hats sometimes can be pretty challenging. And so that person would also, I know last year I was before you, I made a request for funding to pay for some of our defensive litigation costs. Since last year and the hearings, both before you all in the Senate, the AG has represented us. And so I appreciate your support, and of course appreciate them and their assistance when we've needed it since that time. But what it has meant for me as we are going through litigation and having to respond to things, obviously there's got to be a point person on my end, on my staff, handling the meetings with those attorneys, reviewing the pleadings. Hey, we want to add this. Here's our rules on this. And so again, as a general counsel, my idea and my hope would be that they would handle a lot of those things. And so that is all I have. I'm glad to answer any questions that any of you have.
Great, appreciate what you do. Your caseload, I mean, it has, I know you said it, but I mean, from 542 in 2021 to 2,083, at least from a complaint standpoint, in 2025 is, that's a huge difference. Looks like everything's gone up. Cases dismissed, complaints investigated. So I know how important that investigator position is, that the attorney position is that you're looking forward to. What do you actually need? I know this is what you're requesting because of it, but what do you actually need if you had a full ask to make from an investigator standpoint and from an attorney standpoint?
So having 3 investigators would be wonderful. I think that sometimes we joke about having satellite offices, but truly being able to divide up the workload by areas of the state, even I've thought about that. I think 3 would be wonderful. As far as attorneys, adding the 4th right now would be very helpful. I think 5 would be ideal for the kind of work that we have now, especially given the expansion in the area of the training and the guidance as well.
Okay.
But to be clear, I am
know you're not.
appreciative of
That was my
anything.
question,
Okay.
not your proposal.
Okay.
That's clear. And as far as the court reporting costs and expenses, court reporters are in demand, right? That's really the gist of this. Is they know they're in demand and they begin asking. That's significant. $4,000 to $51,000, or almost $52,000 in 1 year difference. So. That did include 2 trials. I guess you didn't have trials in 2025? I didn't look.
So in the annual year 2025, there were 2, but I was asked to capture these figures
year?
by fiscal year.
Okay, yeah. Okay, are there any questions for her? You have one? Representative Holcomb?
Thank you, Mr. Chairman. Thank you for your presentation. I wanted to ask, because the volume of complaints certainly is a variable that impacts the duration of the complaints and the investigation. Can you give us just a little bit of color of how long on an average basis, recognizing that every case is different, but just as a general rule, and let's assume that there's one with merit, so not one that's sort of immediately on its face questionable or even frivolous. What are we looking at in terms of how long that takes?
Let me start at the beginning. So when I started at the commission, when we were around 500 complaints, our goal, and we were normally able to meet it, was to have complaints reviewed and a decision made about, are we going to dismiss at this stage, or is it going to move on, further investigation, go before the investigative panel. We could make that decision 4 to 6 weeks. We are solidly in the 8 to 10 week time frame now, and that is for initial review of our complaints. Again, 8 to 10 weeks. Obviously, if we have something that is emergent, if we get information that a judge may be engaging in conduct that's criminal, or showing up to work intoxicated, sleeping, those kind of things, they're going to jump the non-emergent, if you will. But we're looking at really 8 to 10 weeks just for us to make a determination on the front end about what needs to happen. Obviously, there are some that come in and we can see, okay, this is a legal or an appellate issue, and we'll screen it out. But 8 to 10 weeks on the front end, and then depending on the complexity of the complaint. So sometimes we get complaints, and when we talk to person A, they say, let's say it's an attorney, you need to talk to these other 2 attorneys. They have information for you. Depending on how many additional interviews we have to do, or court observation, I would say once we get past the first 2 or 3 months and we're before the investigative panel, I would say average now anywhere between an additional month to 3 or 6 months. And so that is just for us to work our way through the investigation and get to a place where the panel is making a recommendation regarding resolution. I can say that the first time I believe I presented in front of you all as the director, we did have a backlog at our hearing panel level as well. And so there were a few cases pending trial. I can tell you that we have worked all the way through that backlog. There is no backlog at our hearing panel level, but there is, there are several cases down at our level right now that we need to resolve because they've been pending a long time. So, what would be ideal for me is not that they're, pending recommendation or resolution for 6 months, but that within that time we could get them charged and move on to litigation if we need to. So I'm sorry, my answer is if it's non-complex, then a month, 2 months, we can get a decision made right now. But if it's complex and we're doing more investigation and we're seeking discipline, I would say 6 months, and some of them have even been longer than that.
And if you received additional resources along the lines of what you said, like if money weren't an issue, how much would that improve efficiency and the rapidity with which you could resolve those?
So I think it would help a great deal. If we were to get a second investigator position, my plan would be to have that person, at least when they get on board and they're getting up to speed, have them handle most of the intake review and investigation. So that means when a complaint comes in, they're calling the complainant and any initial witnesses to help us make that initial screening determination more quickly, right? They would handle the bulk of the intake in the initial witness and complainant contact. That would free up my current investigator to dedicate more time to focus on our complex complaints and investigations that require travel, that require the in-person meetings, that require the service of the subpoenas, that require extensive document review. Because right now he is juggling those 2 things. And so on the investigative side, I think it would help a great deal. On the attorney side, I know for me, because I do lead several of the investigations and prosecutions, I can tell you I am oftentimes having to set those down because something else comes up. And I'm, recently we got served like a non-party request for production of documents in a case, I didn't know anything about. And so, you have a certain number of days to respond to that. I was the one that, researched and drafted that response. And it was just based on what other people had going on at the time. But I am often having to set down the things that I am leading on to do some other legal tasks and even non-legal things that my hope would be I could pass along to a general counsel type attorney in the future. And so if I had more of my time freed up, I would prefer to dedicate more time to our investigations and prosecutions. And if I had that time, things would move through the system more quickly, I believe.
Okay, thank you.
Any other questions? All right, well, thank you for what you do. Thanks for being here today. And we'll reach out if we have any other questions, okay? All right, thank you. To my prosecuting attorney's friends. D.A. Cranford, come on up.
Hey, how are y'all? I think we gave y'all each a PowerPoint. Okay. So,
All right, we ready?
all right, thank y'all. I think I know everybody, but I'm Herb Cranford. I'm the DA of the Coweta Circuit. I'm the DA's Association budget chair. I've got Executive Director Scandalakis with PAC and Chris Jones, who's our CFO. And I believe the only DA here is Randy McGinley in the back from the Alcovey Circuit. So appreciate his moral support here. It occurs to me to jump ahead to 8.2. That's a pass-through funding from the Council of Superior Court Judges Clerks. I think everybody's understanding of that on the track sheet, so just to knock that out. I'll start with the conflict case program, section 8.1 at the top of our track sheet. We discussed this in front of joint appropriations, so I'll try to just move through the points quickly, but we're asking for annualizers for funding for those prosecutors, but I think the biggest point here is that was established as a separate program a few years ago because it was believed that an increase in conflict cases after the 2020 election would dissipate. And for reasons I think Representative Holcomb asked about in front of joint appropriations, that hasn't happened. And so our ask is, rather than treat this as a separate program, let's put that under the umbrella of the Prosecuting Attorneys Council, move it to their program. There's always been conflicts. There are more now than there were historically. As an elected DA, if somebody at PAC can't handle a conflict, then I'm getting a call to go to an adjacent circuit to handle it. I think this past year, PAC has handled over 50% of the conflicts occurring in the state of Georgia. So that's allowing me and other DAs, other solicitors, to focus on the cases occurring in our jurisdiction rather than traveling to handle another case. Now, I will say, maybe ad-libbing a little bit in light of earlier conversation and past conversation, maybe there does need to be discussion around, what amounts to a conflict, both for an elected prosecutor and for defense counsel. I also just want to put on y'all's radar, there has been some discussion about reworking, I don't know the right word for it, but the rules about appellate procedure, where right now, as I understand it, if you're going to raise an effective, you have to do it at the initial direct appeal stage, which requires a whole bunch of conflicts at the appellate level. And I think maybe there's some discussion about that changing, and that might reduce a lot of conflicts on the defense side, just, again, to put that on y'all's radar.
Yeah, I thought so too. She said it wasn't very many of those conflicts, though, so.
I'd be curious to see the numbers, a couple things I noted that maybe are just worth pointing out before I get into the rest of our ask. We're asking to move the conflict program within PAC. PAC does have some resource prosecutors, but prosecutors don't have an appellate division. There's no statewide appellate division for DAs. There's no statewide RICO or violent crime division. There's no capital unit for DAs. PAC has people that help us with things, but we've talked a lot about parity between prosecutors and public defenders, and there are some differences there, you know, where they've got some resources and personnel that I don't know that there's a comparable alternative to on the state side. We just got DA's offices. So, you know, a point I just wanted to make y'all aware of as we're trying to compare apples to apples here. I think there's a little bit, a few things that are different. So going into section 8.3 on the track sheet, and I believe this is on the PowerPoint you've been given, starting with the second slide. As we discussed at the joint appropriations meeting, 8.3.1, we're asking for a salary increase for elected district attorneys. There are 51 in the state of Georgia. We're following the framework of the Superior Court judges, who obviously everybody's aware got an increase recently. Their bill gave them 90% of federal district court judge. We're asking for no more than 88% of federal district court judge, understanding, you know, if this passes, how much of that funding is a different question. Does it come in stages is a different question. But the max at 88% of 2022 federal district court judge would be this $196,592 number. That's just, if the bill passes as is, that would be the most according to 2022 federal district court judge. Going to the second slide and the third slide, kind of our rationales, some reasons we think this is important. Having a good DA in every circuit is a serious public safety issue as I see it. It's a law enforcement issue. You could have the best sheriff and police chief, and they could make a lot of arrests, and you know, you get the ball in the red zone, and the DA's office isn't able to get it in the end zone, isn't able to get a conviction, or, you know, maybe gets a conviction to something much lesser instead of, you know, the much more serious crime, you know. So I do think, and some people may have opinions about, you know, in the past this has played out in places across Georgia, you know, and I think having a good DA with trial experience makes a difference in local communities in Georgia regarding public safety. You can see here by comparison, we want competitive pay. We're public servants. We know we're not going to make the going rate for a lawyer in any given community, but competitive pay as compared to neighboring states shows that Georgia is the lowest in all states that touch Georgia at $132,473. And as you can see, if we were to get 88%, and again, we understand that that's probably going to happen in stages at best, you know, that would put us in the middle of that pack, above Alabama, below Tennessee. And you know, as a state that has put a lot of resources into public safety recently, GBI and different things, I think it's important for these communities to have incentive for a good trial attorney to pursue the DA job in their community, instead of maybe one or two people going for, you know, the position in any given location. With the raise y'all gave to ADAs last year, that was a substantial increase. We've presented a 3-year plan for ADA pay. Last year, we were very appreciative. Our people were very appreciative that y'all gave us step one. And you can see on slide 6 those 3 steps. So now starting ADA pay for state-funded ADAs is $72,000, and the max is $134,859. So our point on slide 4 is there are now 83 state-paid assistant DAs who are making more state dollars than their elected DA. And those are career prosecutors, you know, that are the backbone of the office. I think one takeaway from that is the more distance there gets between the highest state-paid ADA in the office and an elected DA, as that DA position comes open, there's an incentive to not pursue it, you know. There's a lot of administrative work, a lot of working with commissions and things on budgets, and I think it's attractive to maybe, I'm already making more money than I would make as DA, and I get to handle a caseload and do the job I love, versus taking on this other job that, yeah, it's elected and you're in the public eye, but you know, there's a lot of other stuff that comes along with it. So I do think it affects quality in the DA's office when you take away a certain incentive for your best ADAs to pursue that job. If the DA goes for a judgeship, you obviously want the best people in your office to want to be in that DA position. So for ADAs, and I'm on slide 5 of the PowerPoint, and this is 8.32 and 8.33. You know, the next several slides or positions on the track sheet. So 8.32 is a step increase for all ADAs on the pay scale that we abide by. 8.37 is year 2 of that 3-year plan that you see below in slide 6, which would take starting ADA pay from $72,000 to $78,000. It would take the top of the ADA pay scale from 134 to 157. To be clear, you know, all of these things are really important to our offices. Getting elected DA pay to be competitive in the market among other DAs in other states, but also continuing to increase ADA pay. Both those things are very important. There are 437 state-funded ADAs in the state of Georgia, and if you go over to slides 7 and 8, you'll see how starting pay has increased on slide 7, but you'll see on slide 8, you know, vacancies dropped in 2025. They've kind of stagnated in the high 30s out of 437 positions. So it's still an issue. It's gotten better recently, but we want to continue to make progress on that. And just as a reminder, that year, that step 1 that started state pay at $72,000 and topped it out at $134,000, that took effect in January 2026. So all of those state-funded ADAs just got that pay increase. That, you know, for a lot of them, $10,000, you know, $12,000, substantial increases just hit, and they're very appreciative to you all for that. A couple of these are annualizers. I'll not go into that unless y'all want me to. A couple things from some prior presentations I wanted to point out. You know, I think we've provided y'all our pay scale a number of times. We could probably give it to you in 10 minutes in an email if we needed to again. Our pay scale is based purely on experience. And when you look at every individual on there, there's nobody higher on that scale than their experience warrants, right? And I heard that, you know, maybe a significant number would be higher than experience. I just want to be clear, like, we've followed the rules, you know, and like I said, the top of our pay scale is that 134. So like, there's nobody on our pay scale with state dollars that's making more than that 134. We haven't used county dollars to inflate state pay, you know, and so we're not asking for money to make up for what county dollars have been used to do, you know, and I just think, you know, I just wanted to highlight how we've done business to all of you. We also, I've got one ARPA position that's going to go away in September 30 of this year. You know I've got to go back to my county and ask to get that money. You know, that, like, it's not a thing we considered asking y'all to do, you know, but that's an issue. I'm going to lose that person if the county won't give me the money. So just to point out a few things to you. I think a lot of this is we've covered before. I don't want to take longer than needed here. Slide 10, I think, is worth pointing out. Of all the 437 ADAs, over half are in Class 4, meaning those are the most tenured, most experienced ADAs making the most money. As you go to Class 3, 2, and 1, it's less and less. I think one reason for that is it's been harder to get people in and keep them after 2, 3, 4, 5 years. But another reason is in my office, and I think a lot of other DA's offices, my highest paid positions are state-funded positions. I also get county positions, and it's the opposite in bigger offices, where their lowest paid positions, as I understand it, are often the state positions, and their highest are county positions. And one way to look at that is the state dollars given to DA's offices, whether it be to elected DAs or state-paid ADAs, is disproportionately impactful to the smaller offices. There are some DA's offices that literally get no county money, you know, and so these asks, I think, have a much bigger impact on public safety in these, you know, really small offices that are basically just totally dependent on state dollars. My office is kind of a mix, so I've got an experience with both, but still my highest paid people are these state paid people. And so, you know, that may be a reason why there's a lot more state people at the top of the state pay scale. Once you keep them, you jump them from county to state funded positions. Slide 11's ADA turnover. I know we hit on that at the joint appropriations meeting. But we're still experiencing turnover. That would include somebody going from a state position to a county position, as I understand it. Slide 12 corresponds to 8.3.6. That's it was my circuit, the Coweta circuit. We had the number 4 caseload, number 5 population. We split it in 2024, effective January of 25, and we've been using funds available to PAC to kind of cover the investigator, victim advocate, and 2 legal assistant, 2 administrative positions. So we're asking for full funding for the West Georgia Judicial Circuit to finally get them to full funding for the remainder of their staff. Going to 8.4, that's the PAC proposal, a couple annualizers there. They're seeking 1-step increase. They're also asking for the same 3-year plan we're asking for ADAs would apply to attorneys at PAC. So we're asking for year 2 for that as well. PAC is also asking for funds for a single victim advocate. Again, you know, PAC helps us with cases. PAC handles conflict cases, and rightly, the state of Georgia constitutionally requires victim services. So I think you know that's where that need comes from. And finally, 8.4.6 goes back to what I addressed originally, which is basically taking the separate conflict case program and putting it into the PAC program for the reasons stated. The remainder of the slides cover those various things. Happy to get into any of that, but I know we're last, and so I wanted to try to move relatively quick here. Happy to take any questions.
All right. Yeah, Representative Evans.
Thank you, Mr. Chairman. My first question is, I apologize, really just trying to get a little information that you may have based on some things we were hearing from the public defenders about why they have so many more conflict cases than perhaps they used to. And one of the things that we've been told a couple times now is that these are a lot of jail fight cases where there's a lot of defendants because there's 10 or more people in the jail fights, and I was wondering if you could give us your thoughts on that, based on what y'all know y'all are and are not indicting.
Sure. I don't believe we've done any kind of survey among DAs for that, so I'm kind of forced to speak from my personal experience or talking to another DA here or there. We do jail fight cases, but and maybe this is just a function of my counties and how those jails are run, but it's typically a person or two, like identifying, okay, like who actually started this, and that person gets charged. My experience in jail fights, we're not having brawls. It's more a couple people get in a fight. We can watch the video and say, like, that was the antagonizer, you know, so that's the guy we're going to charge.
Are you all, what circuit are you?
The Coweta circuit, so it's Coweta, Troup, Meriwether counties.
So according to the chart that we got this morning, and if my math is correct, it looks like about 13.86% of the cases are, according to the Public Defenders Council, those are conflict cases. Do you have any sense of what's driving? It's 1,800, no, it's 1,030, I can't tell if that's an 8 or a 0. It's about 1,000 cases
And
for, I guess this is last year. Any sense of what might be the bulk of those, if there's any trend that you can think of?
Yeah, so to clarify, that's the Coweta circuit, 13.86 of the public defender cases in Coweta have been conflicted? Okay.
Exactly, yeah, it says total cases, 7,458, conflict cases, 1,034.
Gotcha.
And my math says that's about 13%.
Gotcha, okay, yeah. And that's roughly 1,000 cases total.
Correct.
So to give you an idea, in Coweta County alone, the last few years, we've received about 1,600 felony cases, excluding probation violations. Going back several years in Troup County, we get about 1,000 felony cases, excluding probation violations. Now, we are under-resourced, so we're behind on getting everything docketed, right? And we decline to prosecute 15, sometimes 20% of the cases we get, just because we don't think we can prove it beyond a reasonable doubt. So I looked on, our two most recent trial calendars in Coweta and Troup, and roughly 50% or less of those cases were public defender cases. So I guess one takeaway is this strikes me as accurate in terms of the number of cases being conflicted by our public defender's office. I will say I don't think they're abusive of the process. I've heard stories about conflicts that occur on the Monday of a trial week, and the effect is the case gets continued, and you can maybe read into that what you will. That's not so much an issue in my circuit, I don't think, but our multi-defendant cases are sometimes drug cases, sometimes violent cases, but we don't have, 7, 8, 10-person multi-defendant cases. So there might be 1 or 2 conflicts on a given multi-defendant case, but if a couple private lawyers get involved, that kind of takes care of it. So, candidly, I don't know if y'all think this is high or low or what, but
No, I appreciate it, and I know it's anecdotal. I just thought, since we had you here, and
Sure, yeah.
that was what we had heard, that's helpful. So thank you for that. And then my other question is about the elected DA pay raise proposal. Do you, or is PAC taking a position about whether you think local supplements should or should not change based on the request that y'all are making?
So I think it's appropriate for me just to be candid about this. The DA's Association first voted on what is now our bill in July at our summer meeting, and we voted to basically adopt the framework of the Superior Court judge pay bill, which would tie us to federal district court judge, increase the retirement age, and cap county supplements. The initial vote was unanimous But as the fall approached and we got into the winter, a number of DAs, maybe 14, 15, something like that, they made arguments, and to do good faith to those arguments, I think it would be, a circuit gets a number of judges based on caseload, but you only get one DA, right? And so they're arguing DAs should be able to keep their supplement. To be clear, I think we would probably unanimously love to keep our supplements, those of us who get them, but plenty don't. County circuit that gets, I want to get all these rural DAs that get very little, a lot of them get no county money. I want to get all of them a raise. And if I want to opt out to keep my supplement, the bill we've dropped allows me to opt out. To clarify, all current DAs, their retirement age would stay the same. So just like judges, the new retirement age, if that passes, would only apply to a DA that took office, I believe, in July 1 of 2026. But yeah, so there is disagreement about whether our bill should include a cap to supplements. A majority, I think a large majority of DAs voted to continue to follow the judge framework of keeping a cap on supplements. And frankly, at least speaking for myself, that's out of a desire to support a bill that I think can pass. And that's, like I said, there are DAs that get no county money, whether a supplement to themselves or help in their offices. And, that's why I'm supporting the bill as is. Like, I'm really working as hard as I can to get those DAs an increase.
No, understood, and I appreciate that, and appreciate that the current DAs could opt out and keep local supplements, but it wouldn't solve the issue for the DA that comes next, like in a large metro county where, to your point, which is perfect as far as my concern, which is that we have tools here to make sure the caseload among judges, no matter what county you're in, are somewhat commensurate. We have no such power when it comes to DAs, and being the DA in, Fulton, DeKalb, Gwinnett, Cobb is much different than smaller circuits. And so I think it's a big concern of mine. I am very sympathetic to the idea that I don't like us on the bottom of the DA pay scale to our neighbors. But I also noticed that, we have more judicial circuits than any of these other states. So I do wonder if those other states have ways of keeping their circuit caseloads similar. I don't know. I would imagine they have the same issues that we do. But I guess it's less of a question at this point, more of a statement. I have no problem raising DA pay. Philosophically, I think we should. But I do have a huge problem doing it at the expense or doing it not recognizing what capping local supplements might do to not the current DAs in metro counties, but in the future, because that would be, to me, very fundamentally unfair. And I think I understand the desire to analogize to the judges, but there's just a lot of differences. And it sounds like you would agree with me that there are a lot of differences. I guess that's the question.
Yes, I think a lot of judges would acknowledge that, particularly those that used to be DAs. I will say, and I appreciate the perspective you've shared there. Again, I think DAs would unanimously support a raise that allows all of us that get supplements to keep them. But to me, it's about supporting what's doable, as I understand it. And I will say, before we split our circuit, like I said, out of 50 circuits at the time, I was in a unique position because I was the biggest multi-county circuit. I had the 4th highest felony caseload according to the AOC numbers, had the number 5 population according to the AOC numbers. And the number one metric of difficulty, if you will, in my experience, has been the number of cases per employee, number of cases per ADA, DA investigator, victim advocate. It got easier with less territory to cover. So I understand many feel the bigger the office, the more difficult, or the more deserving of higher pay. There's probably plenty of good arguments for that. But the jobs of, running a multi-county circuit with no county funding and all you get is one ADA per judge, like, there's a lot of difficulty that comes from that. And my smallest county now is 25,000. Before we split, it was 10,000. So, like I said, I was in a unique position of living both realities. And so I do want to say there's a lot of difficulty to go around for DAs. And I
Sure.
think we're generally underfunded.
Sure. And, yeah, I don't think anybody on this committee would disagree too much with that. And then this is my last question, Mr. Chairman. Has PAC given any thought to tiered pay among the circuits based on size? And I think I'm right when I say y'all do that for different things within your organization, like awards and just different things that you do. There's like small, middle, large, or maybe there's 4. Have y'all given any thought to a tiered salary increase request?
Yeah, the DA's Association, one DA back in the summer, if I recall correctly, did propose an alternative that did propose a cap on supplements at 10%, but came up with 3 categories of state pay. And that was discussed, but like I said, didn't get support. And so at that time, there was unanimous support for adopting the judge framework. So there was a discussion back then. The 2 options were, both cap 10%, but one would, quote unquote, small offices would make a certain amount, medium another amount, bigger offices a different amount. As you might imagine, that position did not have anything close to majority support. I think, like I said, because I think a lot of DAs in really difficult situations in small offices look at a DA in a really big office with 100 ADAs and aren't convinced that job is deserving of more pay than their job.
Mm-hmm. No, I appreciate it. And Mr. Chairman, it may be that, I know if we had unlimited funds, it's easier, but since we don't, and if we can only do one thing, just like if we can only do one thing with the public defenders, to me it's parity versus the conflict cases. Here it would be ADAs versus elected DAs, but I do, again, sympathize with the issue, and it may be a point of further study where we also talk to big, middle, smaller site, like we bring folks in and talk about it this summer and figure out what we as the state lawmakers and the state appropriators think would be fair. It's kind of like what we did with the judges, because it doesn't sound like, whether it's the proposal that used to be unanimous, whether it's a tiered system, there's really just doesn't sound like a lot of consensus among the DAs. And so I don't know that it's, if that is the driver of anything, I don't think we have it. That's just my observation at this point.
Thank you. Yep, I think we're always, I know I'm always willing to put in work and get to a good answer. That's what's important. Are there any other questions, committee?
If I may,
Sure.
offer a thought to that, given that all current DAs could opt out if these bills pass, if there is a desire to further study this down the road or whatever, I would recommend, I don't know what the right phrase is, but let's get this done, and current DAs could opt out. And if there needs to be more study down the road for something else that might get legislative support, I'm sure we would be happy to engage in that and participate in that. I think there's about to be a lot of judge retirements, and I'm worried about what's going to happen to the ranks of DAs and how that's going to affect a lot of communities, particularly small communities that don't have a lot of lawyers. And I think this is like a real public safety issue to make sure we're maintaining competitive pay for quality DAs. And so I think it is a priority, along with all these other priorities, to get that done this year.
Yep, great. I do have one question before you leave, I'm sorry.
Sure.
838,
8.8?
8.3.8,
Okay.
this is just for the Gwinnett, the middle and the northeastern judicial circuits. Is that half the money that you need for the year, or is that the full? It's
That
302,000.
that must be half if it's only 300,000. Yeah, that must be half.
Okay. You're gonna ask for the full in the future, right?
Annualize next year.
Talking about new circuits, you're always gonna ask for the full in the future, right?
Yes.
Yeah, we are. Okay, and, yeah, let's see what other questions I had, I'm sorry. And just so I'm clear, the 832 is for a step increase for everyone, but 837 is for the full year 2 of the plan.
That's correct.
Okay. And if you had to pick one of those two, I'm sure you're picking year 2 instead of the step, am I right?
Yes, we would love year 2 of the plan. We recognize that's a large number, though.
Okay, and one last, 836, which is the one that you're looking to just try to fulfill West Georgia Judicial Circuit and some of the positions that you had there.
Mm-hmm.
Have the things that caused that to get hosed up, have they been discussed, and have we made kind of any movement on that? As far as making sure this gets across the finish line, or is it just an ask and hope again?
I don't know that I have an answer to that. Maybe Mr. Scandalakis does.
I think there's been some misunderstanding about how the formula works.
Okay.
There's a formula in place that each DA gets one assistant DA per judge plus 2 more, 1 investigator, 1 victim advocate, and 2 admins. The House has consistently funded all that full formula. For some reason, when it goes over to the Senate, some of that formula has been taken away, and the positions that are by statute have not been funded. And that's why we're asking them to be fully funded.
Yeah, I recognize and understand that, and I guess what I'm asking is, has conversations to...
Yes, sir. I've had conversations with the chairman over there, and I think last year I had it when I saw what the budget came out, and I'll intend to have them again.
Okay. All right.
Ma'am, and I can make one pitch too. In the PAC program, we're asking for 1 victim advocate. D.A. Cranford has told you that the prosecutors of the Prosecuting Attorneys Council have taken on about 56% of the caseload that has come in. I now have conflict attorneys that go from Dublin, Georgia, up to Athens, all over the place, and I only have 1 conflict victim advocate, and she can't be in 2 places at one time. And I respectfully request that that position get funded.
Understand, yep, I think that's important. Okay. There are no more questions. Thank you guys so much. Thanks for being here.
Appreciate it.
You bet. And with that, we're adjourned.